Hey everybody, Daniel Gaines here. How y'all doing? Just wanted to jump on real quick and do a real quick video. Just kind of to the point. The last video I did, some clown, Matt something or another, is commenting on it. It's Juliette or one of her friends is who it is. Talking all this shit, talking about the U.S. Supreme Court says this, this, and this. So, just further proof these fucking fools have no clue what they're talking about. And since he wants to accuse me of the sovereign citizen shit, which I say all the time, don't fucking use it, doesn't work. So, since I'm being accused of that, I just want to show a few things real quick. Just to shut people up on this. Because they're too stupid. See, it's like this. These people that I'm dealing with, the state of Washington and everything else, every time I deal with them, I'm literally the smartest one in the room. This is all going to be proven very, very soon. It's actually they're all about to be finished. Their careers are about to be finished. The end of this month is when the last door will be closed and I can move to my federal filing, and that's when they're all done. But they're too stupid to understand the game that they caused by the games that they played. So they started this game. I'm just going to finish it, and since they're too ignorant and stupid to understand what's really going on here, I'm going to throw them a bone. And I'm going to shut people's mouths right now because I can't stand when people say I don't know what I'm talking about. Like, I really haven't spent the last 17 fucking years doing this. Like, I really haven't sacrificed so much of my fucking life. Sleep, social events, and everything else to spend fucking reading case laws, and everything else. So, let's get into this. I'm going to read through it all first, and then I'll show, just that way y'all can see that it really is legit cases. Y'all can go fucking look it up yourself. That's more so directed to the idiots who are looking at this, DCYF, Juliette, the attorneys, people like them. Everybody else, I mean, if you want to, you can look it up to help educate yourself too, because it's all very good information and very vital and useful. So let's get into this. Under federal law, which is applicable to all states, the U.S. Supreme Court stated that if a court is without authority, its judgments and orders are regarded as nullities. They are not voidable, but simply void, and form no bar to a recovery sought, even prior to a reversal in opposition to them. They constitute no justification, and all persons concerned in executing such judgments or sentences are considered in law as trespassers. Now, that case is from 1828. And I know what some people are going to say. 1828, that doesn't mean it's still good. It's too old. It's not standing anymore. Well, actually, there's a lot of case law still from that time frame, and even some that's older, that's still very valid and still very much standing case law. This case happens to be one. However, here's one from 1991 from the U.S. Supreme Court. It goes on, and the quote I'm going to take from it is, "A judge is not immune from actions, though judicial in nature, taken in the complete absence of all jurisdiction." That means that the judge, whenever they lack jurisdiction, they're not acting in their official capacity as a judge. We'll get into that. Hold on. Now, an officer of the court. A judge is an officer of the court, as well as are all attorneys. A state judge is a state judicial officer paid by the state to act impartially and lawfully. A federal judge is a federal judicial officer paid by this federal government to act impartially and lawfully. State and federal attorneys fall into the same general category and must meet the same requirements. A judge is not the court. 1980. Standing case law, Supreme Court. Oh, well, actually, that's the appellate courts, but still, it's still valid and standing. So my bad, not the Supreme Court, it's the appellate courts. Fraud upon the court. Whenever any officer of the court commits fraud during a proceeding in the court, she is engaged in fraud upon the court. In Bullock v. United States from the 10th Circuit Court of Appeals from 1985, the court stated fraud upon the court is fraud which is directed to the judicial machinery itself and is not fraud between the parties or fraudulent documents, false statements, or perjury. It is where the court or a member of the court is corrupted or influence is attempted, or where the judge has not performed his judicial functions. Thus, where the impartial functions of the court have been directly corrupted. Well, the influence is the financial incentive these judges have from these federal programs where they get federal kickbacks from the state. So, that's why there's been fraud in my case. But hold on, it gets better. Much, much better. Fraud upon the court has been defined by the 7th Circuit Court of Appeals. 7th Circuit Court of Appeals is the 7th Federal Circuit Court of Appeals. To embrace that species of fraud which does or attempts to defile the court itself, or is a fraud perpetrated by officers of the court so that the judicial machinery cannot perform in the usual manner its impartial tasks of adjudicating cases that are presented for adjudication. 7th Circuit further stated as a decision produced by fraud upon the court is not in essence a decision at all and never becomes final. It's not a decision and never becomes final. Fraud upon the court makes void the orders and judgment of that court. It is also clear and well-established laws. This is actually from Illinois, but hold on, it applies still. Hold on. It is also clear and well-established Illinois and well-settled Illinois law that any attempts to commit fraud upon the court vitiates the entire proceeding. The people of the state of Illinois v. Sterling, that fraud vitiates every transaction into which it enters, applies to judgments as well as to contracts and other transactions. The maxim that fraud vitiates every transaction into which it enters, it is automatic that fraud vitiates everything. These are multiple different cases, blah, blah, blah. Now, I know what somebody's going to say, well, that's Illinois, that doesn't apply. Well, under Illinois and federal law, which is where it does apply, even though it's Illinois law as well, and these are Illinois cases, it's still based upon federal law and federal statutes, so that's how it does apply to the state of Washington, because it's federal. When any officer of the court has committed fraud upon the court, the orders and judgments of that court are void of no legal force or effect. When any officer of the court has committed fraud upon the court, the orders and judgments of that court are void of no legal force or effect. Now, let's get into some more fun stuff. Federal law requires the automatic disqualification of a federal judge under certain circumstances. Now, I know what people are going to say. Well, if it's talking about federal judges, it doesn't apply to state judges. Well, actually it does, because it's a federal law. I'll get to that in a second. But since it is a federal law, anytime that you're dealing with matters of protected rights, constitutionally protected rights, the supremacy clause is in effect. Once the supremacy clause is in effect in any matter, if the supremacy clause is in effect, federal law does apply. In fact, if federal law and state law contradict, federal law is the supreme law of the land. That's legit what it comes down to. So, in 94, the U.S. Supreme Court held that disqualification is required and if an objective observer would entertain reasonable questions about the judge's impartiality. If a judge's attitude or state of mind leads a detached observer to conclude that a fair and impartial hearing is unlikely, the judge must be disqualified. Litke v. U.S., 94, like I said. Courts have repeatedly held that positive proof of the partiality of a judge is not a requirement. Only the appearance of partiality. What matters is not the reality of bias or prejudice, but its appearance, 7th Circuit Court said. 28 U.S.C. 455A, which is the federal law that you cite to apply this to state courts when you're dealing with matters of protected rights, is directed against the appearance of partiality, whether or not the judge is actually biased. Is irrelevant. It is not intended to protect litigants from actual bias in their judge, but rather to promote public confidence in the impartiality of the judicial process. The courts also stated that Section 455A requires a judge to recuse himself in any proceeding in which his or her impartiality might reasonably be questioned. That's Taylor v. O'Grady, which I've used before in multiple different courtrooms to multiple different judges, and they've ignored. The court stated that it is important that the litigant not only actually receive justice, but that he believes he has received justice. The Supreme Court has ruled and has reaffirmed the principle that justice must satisfy the appearance of justice. A judge receiving a bribe from an interested party over which he is presiding does not give the appearance of justice. Recusal under Section 455 is self-executing. A party need not file affidavit in support of recusal, and the judge is obligated to recuse himself or herself sua sponte under the stated circumstances. Sua sponte basically means on your own. The courts do it on their own. That's what sua sponte means. And again, that's Taylor v. O'Grady. Further, the judge has a legal duty to disqualify himself even if there's no motion asking for a disqualification. Judges do not have discretion not to disqualify themselves by law. They are bound to follow the law. Should a judge not disqualify himself as required by law, then the judge has given another example of his appearance of partiality, which possibly further disqualifies the judge. Should another judge not accept the disqualification of the judge, then the second judge has evidenced an appearance of partiality and has possibly disqualified himself or herself as well. None of the orders issued by any judge who has been disqualified by law would appear to be valid. It would appear that they are void as a matter of law and are of no legal force or effect. None of the orders issued by any judge who has been disqualified by law would appear to be valid. It would appear that they are void as a matter of law and are of no legal force or effect. We're getting there. 1 second. Should a judge not disqualify himself, then the judge is in violation of the Due Process Clause of the United States Constitution. The right to a tribunal free from bias or prejudice is based not on Section 144, but on the Due Process Clause. And oh yes, it does cite the 14th Amendment. We're getting there. Hold on. Should a judge issue any order after he or she has been disqualified by law, and if the party has been denied any of his or her property, children are considered, as foolish as it is, children are considered property under the law. Whether you agree with that statement as children are property is irrelevant. That's how it's listed under the law. So, if the party has been denied any of his or her property, then the judge may have been engaged in a federal crime of interference with interstate commerce. The judge has acted in the judge's personal capacity and not the judge's judicial capacity. It has been said that this judge, acting in this manner, has no more lawful authority than someone's next-door neighbor, provided that he is not a judge. However, some judges may not follow the law. If you are a non-represented litigant, and should the courts not follow the law as to non-represented litigant, then the judge has expressed an appearance of partiality, and under the law it would seem that she has disqualified himself. However, since not all judges keep up to date on the law, since not all judges follow the law, it is possible that judges may not know the rulings of the Supreme Court and other courts on this subject. Notice that it states disqualification is required and that a judge must be disqualified under certain circumstances. See, the Supreme Court has also held that if a judge wars against the Constitution, or if he acts without jurisdiction, then he has engaged in treason to the Constitution. If a judge acts after he has been automatically disqualified by law, then he is acting without jurisdiction, and that suggests that he is then engaging in criminal acts of treason and may be engaged in extortion and the interference with interstate commerce. Courts have repeatedly ruled judges have no immunity for their criminal acts. Judges have no immunity for their criminal acts. That means if the judge has engaged in any criminal conduct, they have no judicial immunity. If they act outside their jurisdiction, they have no judicial immunity. All fact, all law, all held by the courts. But anyway, before I can get accused of, oh, that's not actually case law, blah. Right here, let me just go ahead and shut some mouths and show. Clearly see the sightings. You can clearly see it all. So clearly it's real. Clearly it's standing. Clearly it's applicable case law. So you can pause, scroll through it all, read through it. You can look at it. You can scope it out. You can fact check me, which if you're trying to use this in your court matter, I encourage that you fact check anything anybody tells you. You don't want to trust anybody blindly because a lot of people think they know what the fuck they're talking about when they really don't. Some people know the concepts but don't understand its applications. So it's best to fact check everything. Juliette, as far as you or the person you're having comment on my videos talking about like how you know things because you've read a Supreme Court a quote from a Supreme Court case or two, I'll give you this little hint. The way case law works is, if it's not related to your case, if nothing's applicable from the case law you're citing to your case, you cannot use that case law. It doesn't apply. You can only cite case law where there's similarities between that case and your case. It doesn't have to be the exact same, like some will tell you, because nothing's ever going to be the exact same, but there has to be sufficient similarities. You can't just find a Supreme Court case that says something that you want it to say and think that that's actually what it is. See, due process is a thing. You're talking about matters dealing with protected rights, parental rights, Second Amendment rights. You're talking about multiple constitutional amendments. So the 14th Amendment is greatly in effect and must be even more securely safeguarded than in any other type of matter, according to the Supreme Court, since that's what you want to use. As such, when fraud vitiates everything, and this is wrought with fraud literally from day one when you initially filed the documents, everything, literally, that has happened since is a nullity. It's void. It's not even voidable, it's just void. Taylor v. O'Grady. Beautiful case. Very similar to the circumstances. Very much applicable. 28 U.S.C. 455A. Very much applicable in the state courts. See, look, they don't understand the game I'm playing. Because I didn't want to play a game anyway. All I ever wanted was to be a dad. They started playing this game and forced me to play with them. So fine, I've learned the rules. I've learned more than they have and become the smartest one in the room. And now I'm going to end the game. What they don't understand is I'm doing things intentionally. I'm sending these emails I'm sending to be an ass, making these statements I'm making with the specific, explicit intent to have them get it into court, like I knew they fucking would, just to close that door too, so that way there's no possibility the state of Washington gets it kicked when they fail to address it sua sponte. And oh yes, they are going to fail to address it sua sponte. They have every step of the way and they will continue to do so. Watch. They won't hold her to account for her criminality on the 18th during the restraining order hearing. They're going to ignore that and let her go and not say a word to her like they always do. And that's fine, because that judge is going to be disqualified right from the start of the matter. And that's another game that I'm playing. See, not only am I closing all these doors, I'm disqualifying all the fucking judges in the county. Oh yes, that's real. So far, every commissioner and judge, literally everyone who has touched this case, is disqualified from touching this case. Everyone. So that means eventually they're not going to have any judges to hear this matter as it moves forward, because they're already down to a very fucking limited number. As such, everything they do is null and void. Everything they do is without jurisdiction, so it's all criminal. Everyone who touches this is liable, and they all are going to get named in the lawsuit and sued the fuck out of. I'm coming for their jobs, and I'm coming for their pockets. And the state of Washington, I'm coming for its coffers, because it wants to encourage this type of criminality by not doing anything against the perpetrators or anything to punish the perpetrators. So y'all can keep playing games, keep reading one or two Supreme Court quotes and think you know what you're talking about. That's cool, go ahead. I'll keep spending my time working on these legal writings I'm doing, and just studying and learning all this shit. Keep wasting your time, I'll keep using mine efficiently. While y'all play checkers, I'll keep playing this game of chess that we've set up. While y'all are fucking thinking you know what you're doing, I'll keep disqualifying every fucking judge and commissioner y'all put in front of me. And then we go to the federal courts where all of you will be fucking held accountable. All of you. And that's the name of the game. So, that being said, love y'all. Have a good night. And again, this video is just to shut up Juliette and show her that she really doesn't know half as fucking much as she thinks she does, and that this has all been set up from the start, every fucking step of the way since they decided to play with me. Ever since they started playing this game, it's all been set up from the start for this end game. All they had to do was comply with the law at any step during the way, and we wouldn't be here. They wanted to play. You don't play with somebody you can't beat. That's just stupid. But to all you good-hearted folks out there, all you people that support this shit and support the men who are, well, the parents who are dealing with this bullshit criminality, I love you. Thank you for your support. Y'all have a good night. Peace.